In London, Ontario, the jury in the sexual assault case involving 5 former World Junior hockey players has been discharged as this trial now becomes a judge-only case. Ontario's Superior Court Justice Maria Carocha made the ruling citing concerns over potential jury bias. The decision came after a juror sent a note to the judge telling her that some of the panel felt that 2 of the defense lawyers were laughing at them as they came into court each day. This case has already seen 1 mistrial. Both the defense and the prosecution agreed to continue with only a judge in an effort to avoid a second mistrial. Michael McLeod, Dylan Dubé, Alex Formanton, Carter Hart, and Cal Foote have all pleaded not guilty to sexual assault. And here to break down how this case got to, well, where we are at this point and what could come next is defense attorney Alex Karapancev. Alex, thank you so much for joining us today. I want to start by getting your reaction. We've seen the last few weeks evidence presented. We've seen grueling cross-examination, and then abruptly there's this change. Well, it's abrupt for us who are not in the court. I want to know, how common is it to go from jury to judge in a trial like this?
Thanks for having me, Faiza. This situation is really unprecedented. It rarely happens, particularly for the purpose that we've seen in this case. As you mentioned, we learned today that Justice Carocha dismissed the jury for the second time in the same case. The first time it ended in a mistrial. Now the case is proceeding judge alone because the court received a note from some of the jurors yesterday indicating that they felt like 2 of the defense lawyers were laughing at them in the beginning of court. The defense lawyers denied it. Her Honor said she didn't notice anything untoward. However, in the circumstances of the case, she said that given these issues existing with the jury, their ability to judge the case impartially may have been tainted. And that's why she dismissed the jury, and we're now proceeding with a judge-alone trial.
We're going to point out that you have no involvement in this case here. You're simply observing, like many of us. But I'm wondering if you can give us some sort of insight. As a lawyer, what are you thinking, whether it's the prosecution or defense? And what sort of changes now? Does your strategy change at all?
Yes. So I think both sides, the Crown and the defense, plan to have a jury trial. The Crown has been presenting their case. They presented their lead witness, the complainant, and they did so before a jury. So we heard the Crown, when making arguments against dismissing the jury initially, that they told the judge they'd gotten ready to present their case with the jury, that's how they'd been anticipating on presenting their case. They're now going to have to perhaps reassess their strategy. Judge-alone trials are slightly different than jury trials. However, I think at the end of the day, not much will change. Justice Carocha has been presiding over this trial from the beginning. She's heard all of the evidence. She's witnessed all the testimony from the different witnesses and complainant. So I think ultimately there won't be major changes in how the trial is run. However, at the end of this trial, should either side be unhappy with the verdict, I really wouldn't be surprised if this issue gets raised on appeal.
That's interesting. And you mentioned the complainant there. Many would say that the cross-examination by the multiple defense lawyers was grueling, to say the least. It lasted more than a week. Is there a possibility that the judge may want to hear from the complainant again, and so that complainant may need to take the stand and answer some more questions?
No, I don't think that'll happen. The complainant's evidence is finished. She gave her evidence in chief with the Crown, and then each of the defense teams had their opportunity to cross-examine her. The judge witnessed all of that evidence. I really don't see the complainant being recalled.
For the judge, does her role change at all now that she is assuming a new role?
Well, she's now going to be not only the judge advising on the law of the trial, she's going to be the finder of fact as well. The jury had the role of being finder of fact at this trial. It was their job to listen to the evidence and decide what happened and whether or not the Crown can prove its case beyond a reasonable doubt. Now, the judge has that role as well. And one major change that we're going to see is that now reasons will be delivered at the end of this trial in support of whatever verdict is reached. When a jury deliberates, they simply provide a verdict of guilty or not guilty for each of the defendants. They don't provide reasons for that verdict. With a judge alone trial, though, that's very different. Judges must provide reasons for their verdicts. So now, at the conclusion of this trial, we will hear reasons from Her Honor as to why she acquits or convicts these defendants.
This is an interesting trial for just so many reasons here. Alex Karapancev, as always, we thank you so much for taking the time to be with us today.
Thanks for having me, Faiza. It was a pleasure.